Trump will remain on the ballot despite efforts in some states to make him ineligible for the 2024 election. The Supreme Court yesterday unanimously rejected the ruling from Colorado Supreme Court that removed the former president from the ballot based on Section 3 of the 14th Amendment. Now, the justices ruled that a patchwork of decisions around the country could send elections into chaos if state officials had the freedom to determine who could appear on the ballot. The decision makes clear that it is up to Congress to enforce the insurrectionist clause against federal office holders and candidates. But the three liberal justices accused their conservative colleagues of going too far by ruling Congress must enact new legislation in order to ban a presidential candidate. They wrote that this decision will make it harder to bar, quote, an oath-breaking insurrectionist from becoming president. Willie.
Let's bring into the conversation former U.S. Attorney and MSNBC contributor Chuck Rosenberg. So, Chuck, this was widely expected. I don't know if it was expected to be unanimous, but it is at 9-0 on the vote here. I should point out conservative Justice Amy Coney Barrett also wrote a concurrence critical of some pieces of her colleagues' ruling on this. This talks about federal office holders, which is to say the state does not have the right to keep a federal candidate off the ballot. It can do that with state candidate and local candidates, but not federal. Are you surprised at all by anything you saw in this decision yesterday?
Not really, Willie, with one asterisk. If you had listened to the oral argument last month, it was pretty clear that the vote was going to be lopsided, 8-1, 9-0, turned out to be 9-0, to prohibit states from determining the qualifications for candidates for federal office. So the 9-0 vote didn't surprise me very much. There was, as you noted, a concurring opinion and a disagreement. Not just the three so-called liberal justices, but Justice Amy Coney Barrett as well, who thought that the majority on the court went a bit too far. A bit too far, Willie, by deciding a question not before them, which was, how do you give effect to the disqualification clause of the 14th Amendment, the one that Mika just so ably described? Do you have to do it through congressional legislation? 5 justices said yes, and 4 said you don't need to reach that question. But on the core question, the most important question, it was a 9-0 vote prohibiting states from determining whether or not someone can stand for federal office.
So, conservative columnist David French writes about the decision in a new piece for the New York Times entitled "The Supreme Court Just Erased Part of the Constitution." And here's part of it. As of Monday, March 4th, 2024, Section 3 of the 14th Amendment of the Constitution is essentially a dead letter, at least as it applies to candidates for federal office. Now, Section 3 is different from other sections of the amendment. It requires federal legislation to enforce its terms, at least as applied to candidates for federal office. Through inaction alone, Congress can effectively erase part of the 14th Amendment. The Supreme Court has effectively replaced a very high bar for allowing insurrectionists into federal office, a supermajority vote by Congress with the lowest bar imaginable, congressional inaction. The fact that Congress has not acted should not effectively erase the words from the constitutional page. Chaotic enforcement of the Constitution may be suboptimal, but it's far better than not enforcing the Constitution at all. What do you make of that, Joe?
Well, I was going to ask Chuck his opinion on David French's insights. Chuck?
Yeah, Joe, I read it this morning. I read his article, and he makes a really important point that Congress, by doing absolutely nothing, which is absolutely what they do best, has essentially stripped the disqualification clause from operation, right? They've essentially made it, they've rendered it moot. Here's the problem. By going too far, the Supreme Court has really limited the ways in which someone can be disqualified. You need Congress to pass federal legislation. Now, Amy Coney Barrett and the 3 so-called liberal justices would have said something different. A, we don't have to decide this, but B, there might be other ways for Congress or federal courts to breathe life into the disqualification clause. So I think David French's article is an important one to read. Like I said, I read it myself. I even understood it, which doesn't happen all that often. But he's right. It has essentially become a nullity. The ability to keep an insurrectionist from the ballot turns on Congress acting. And as we discussed earlier, that's what Congress does worst.
You know, Willie, this underlines a point that we've at times said about what could be happening on the left, like the criticisms of Alvin Bragg, bringing a case under a new theory or sort of piecing things together in a way that make constitutional scholars uneasy on both sides. In this case, you have the Supreme Court lurching too far to the right, making, as David French said, this part of the 14th Amendment a dead letter. You could also raise a lot of the same questions, which we need to do, about some of these state cases as well. Right now in Fulton County, there's mess down there with the prosecutor. What happens if there's a prosecutor in West Texas that wants to, charge the next Democratic president? These are all questions that do need to be raised, and we've been raising them on one side on, is there overreach on the left that will impact future Democratic presidents? Here you have overreach, it seems, by a conservative Supreme Court who, well, let's just face it, that's what they've been doing best over the past year or so. Overreach by the Supreme Court in a way that, again, has nullified, effectively, as David French said, nullified an extraordinarily important clause in the 14th Amendment.
Yeah, and that's why it was so interesting to see that concurrence, not just from the more liberal members of the court, but from Justice Amy Coney Barrett saying to her colleagues, guys, we need to turn down the temperature, not turn it up and create more chaos in our system. So she, while voting with the majority, of course, unanimous, critical in some ways of the specifics of the ruling. That's the legal side of it, John. Let's talk about the politics for a second. I think we all have heard from some Democrats and maybe people working on other campaigns saying this was worth pursuing, but perhaps even a little relief that it turned out this way, because if he's kept off the ballot, it gives him rocket fuel for the next 8 months to say the Biden administration, the Justice Department, et cetera, everything he likes to say, is trying to strip away your right to vote, to keep me off the ballot. So they say, we can beat him in Colorado, put him on the ballot.
Right. A sigh of relief from a lot of Democrats yesterday. The idea being that if a few blue states had taken him off the ballot, yes, that it would just fuel his grievances, his deep state conspiracies, and would just fire up the enthusiasm. And I think chaos is the right word. I think that they were right to rule the way that they did. A lot of campaigns would concur on that. Now, Donald Trump, of course, appeared yesterday at Mar-a-Lago. He praised the decision. And also, Chuck Rosenberg, we heard from Trump talk about the other matter that's about to be in front of the Supreme Court, that of presidential immunity. We know those oral arguments are scheduled for next month. Just give us your latest thinking as to how those arguments could go and when, perhaps most importantly, when we'll hear from the justices in terms of their decision, because that will impact whether or not any of these trials happen before the election.
Yeah, let me start with the when, Jonathan. The argument in the Supreme Court on the question of presidential immunity from criminal process is April 22nd. The Supreme Court term ends at the end of June. So we will certainly have a decision, or we should have a decision, by the end of June, although it could come quicker. The decision in the case we were just discussing on the 14th Amendment disqualification clause took about 4 weeks. So no later than the end of June, we should have a decision. I am still somewhat bullish. I may be the last person on the planet who believes that this case could be tried before the election, the January 6th insurrection case in federal court in Washington. The sooner the Supreme Court makes a decision, the clearer it will be whether or not we can have that trial. So to your first question, Jonathan, Mr. Trump lost decisively in the district court and again decisively and unanimously in federal court of appeals on the immunity question. I expect he will lose again. The answer seems pretty clear. A president is not immune for conduct while president, except perhaps in a very narrow band of cases involving official acts. And trying to thwart a fair and free election cannot possibly be an official act. So the sooner the Supreme Court gets to that determination, the clearer the better we will know whether or not we can have a trial before the election. I still think we can. Like I said, I might be the last person on the planet, but I'm somewhat bullish.
Okay, former U.S. attorney and MSNBC contributor Chuck Rosenberg, thank you very much for coming on the show. And